If you're applying for a green card through marriage, there is something you need to hear before you file. Your marriage certificate is not proof that your marriage is real, not to the USCIS. A marriage certificate proves one thing, that a legal ceremony took place on a specific date. It does not prove that you built a life together, and that is what the government is actually deciding. I'm Attorney Joseph Botelho with the Botelho Law Group, and a marriage-based immigration is one of the areas our office handles every single week. In the next 15 minutes, I'm going to walk you through exactly what USCIS is looking for, what evidence carries the most weight, and the mistakes we see sink otherwise legitimate cases. Everything I cover today is from a written guide our office put together. It's free, and the download link is in the description below. Grab it now so you can follow along. In every marriage-based green card case, USCIS is legally required to decide one question. Was the marriage entered into in good faith? Meaning, was it based on love, commitment, and a genuine shared life? Or was it entered into to obtain an immigration benefit? Here is what your marriage certificate does not prove. It does not prove you intended to build a life together. It does not prove you combined your finances. It does not prove you'll live together in a shared home. It does not prove you presented yourself to the world as a married couple. It does not prove your relationship existed before the wedding or it continued after. It does not prove you stayed committed to each other through everyday life and through hard times. Everything else in your file has to do that work. Let us talk about the standard because people misunderstand this constantly. The burden of proof is on you, not on the government. You are the applicant and you have to establish your eligibility by what the law calls the preponderance of the evidence. In plain English, USCIS has to be persuaded that it is more likely than not your marriage is real and ongoing. That is a lower bar than a criminal case, but it is still a bar and you have to clear it with documents. And officers do not review your file one piece at a time. They review it holistically. They are asking 4 questions about everything you submit. Is it relevant? Meaning, does it relate to your actual shared life? Does it have probative value? Meaning, how strongly does it support your claim? Is it credible? Is it genuine, consistent, independently verifiable? And totality. Does the whole picture add up to a real marriage? Here is the principle that should guide everything you gather. The strongest evidence is evidence that would exist whether or not you are applying for a green card. Documents created in the ordinary course of your life, not documents created for the immigration file. So what happens if you do not submit enough? First, USCIS can issue a request for evidence. That is a delay for months, and it is, in the best case outcome, on this list. Second, they can schedule a more intensive interview, including what is called a Stokes interview, where you and your spouse are separated and questioned individually and your answers are compared. Third, they can refer your case to a fraud investigation. And fourth, they can deny it outright. I want to be clear about something. Real couples get denied, not because their marriage was fake, but because their file was thin. That is a preventable problem, and preventing it is exactly what this video is about. Officers are trained to notice certain patterns. Here are the ones that draw extra scrutiny. A large age gap difference between the spouses, different cultural, linguistic, or religious backgrounds without any explanation in the file. A marriage that happened very shortly after the couple met in person for the first time. Spouses who could not communicate in a common language. No cohabitation. Spouses living at different addresses. no joint financial documents of any kind, little or no contact history before the application, a prior immigration violation by the beneficiary, a prior denied petition involving the same beneficiary, filing the petition almost immediately after the wedding, and a prior finding of marriage fraud. Now, hear me clearly. None of these disqualifies you, not one. What each does is raise a question, and a question that goes unanswered in your file becomes a doubt in the officer's mind. So, if any of these apply to you, you do not need to hide it. You need to explain it and you need to build extra evidence around it. Our guide organizes evidence into 3 tiers. Let's start with tier 1, the heavy hitters. Number 1 is joint financial evidence. Financial records are hard to fabricate, and they show 2 people genuinely building a shared economic life. Joint checking and savings statements. Here is the key. Covering multiple months, ideally 3 to 6 months or more from different periods. Show that both of you actually use the account. Deposits going in from both sides, withdrawal for household expenses, joint credit cards, or evidence that one of you is an authorized user on the other's card, joint loans, auto financing, co-signed obligations. If you own property, the mortgage statement and the deed listing both of you. Retirement and investments accounts, naming your spouse as beneficiary. Even Venmo, Zelle, and PayPal history between the 2 of you for household expenses. Here is my best practice note on this one. Consistency over time beats volume. A thin file that spans 2 years is more persuasive than a thick file that all comes from the last 6 weeks. Officers notice when everything was gathered at once. Second, in tier 1, joint housing. USCIS places significant weight on proof that you live together. A lease with both your names on it, utility bills, electric, gas, water, internet, phone, renters or homeowners insurance listing both spouses, driver's license showing the same address, voter registration, vehicle registration, mail addresses to both of you at the same address spread out over time. And if only one name is on the lease, get a letter from your landlord confirming you both live there. Do not just leave the gap. Third, joint tax filings. These are among the most powerful documents you can submit because they are federal filings made under the penalty of perjury. Submit joint federal returns. Better yet, order IRS tax transcripts. Those are free from the irs.gov website, and officers prefer them over copies. If you file separately, that is not fatal, but explain why in writing. Fourth, insurance and benefit enrollments, health, dental, and vision plans listing your spouse, employer open enrollment forms, life insurance naming your spouse as a beneficiary, emergency contact forms at work. These documents say something specific about a marriage. They say, I am planning for a future with this person. That is hard to fake and easy for an officer to recognize. Now, tier 2 is where your case becomes a story instead of a stack of paper. If you have children together, that is among the most powerful evidence available. Birth certificates naming both parents, hospital records, prenatal and pediatric records, school and daycare enrollments listing both of you as guardians. Then, photographs. And let me set expectations honestly. No case is approved on photos alone, but a well-organized photo set tells a story nothing else can. Span your whole relationship, early dating, the engagement, the wedding, holidays, both families, not just one side, travel, and ordinary life at home. Label every photo, names, dates, locations, occasion, meaning what were you doing? And this matters. 20 to 40 captioned photographs are more effective than 200 unlabeled ones. Officers have limited time. Make it easy for them. Next, travel documentation. This is some of the most objective evidence you can get because airlines, hotels, border control created it, not you. Tickets and boarding passes with both names, hotels, um, passport stamps, and especially if you met online or a long distance, the flights you took to be together before the wedding. Finally, communication records. These are critical if you have spent any period apart. Text and WhatsApp exports, call logs, video call history, emails, social media posts with dates. Do not dump 10,000 messages. Select representative samples across the full arc of the relationship and make sure the names and dates are visible. Tier 3 fills the gaps. On its own, it will not carry a case, but it rounds out the picture. Wedding vendor records, the venue contract, the caterer, the photographer, the florist. These prove a real event with real planning and real guests. Cards and letters between you. Scan the front, the inside, and the postmark envelope. That postmark independently verifies the date. Estate and emergency planning documents, a will, a durable power of attorney, a healthcare proxy naming your spouse. These carry real legal consequences and people do not sign them casually. Shared memberships and subscriptions, the warehouse club card, the family streaming plan, AAA, the gym. Shared purchases, your vehicle title and auto insurance, furniture and appliance receipts, veterinary records for a pet you own together. A few representative receipts across time is enough. You do not need to submit every grocery run. Now, the pieces most people get wrong: third-party affidavits. An affidavit is a sworn written statement from someone who knows you both and can speak to the reality of your marriage. Documents prove facts. Affidavits explain what those facts mean. They give a human voice to your relationship. Let me read you two versions of the same affidavit so you can hear the difference. Here is a weak one. Quote, I have known John and Maria for several years. They seem very happy together. I believe their marriage is real, end quote. That gets almost no weight. It is vague. It has no dates, no events, no observations. Anyone could have written that about anyone. Now, the strong one. I met Maria in June of 2022 when John brought her to my birthday dinner. At Thanksgiving 2023, I was at their apartment. Maria cooked while John set the table. Their refrigerator had a shared calendar and a chore chart on it. And when John got a job offer in Boston, he called me that night and said he did not take it without Maria's agreement because her nursing program is here in Fall River. Do you hear the difference? Specific dates, specific places, details only someone who is actually in the room would know. And it shows two people making decisions together. Every affidavit needs 16 elements. The affiant's full name, date, place of birth, address, contact information, occupation, immigration status, how they know each of you, how long they have known each of you, at least 2 or 3 specific events with dates and locations, their personal impressions, a statement under penalty of perjury, signature date, and notarization. All 16 are listed in the free guide, so you do not have to memorize them. 2 things to remember: quality over quantity. 2 or 3 detailed affidavits beat 10 vague ones. And variety matters. 1 from family, one from a friend, and one from a neighbor or a religious leader is far better than 5 that all sound the same. And please have your attorney review every affidavit before it goes to USCIS. An affidavit with a problem is worse than no affidavit at all. A few situations that need extra care. If you have lived apart at any point for visa processing, for work, for family, do not let officers discover that on their own. Explain it up front and back it with communication records, travel records showing your visits, and proof of your plan to reunite. If you were recently married and simply have had no time to build a paper trail, lean on your courtship communications, records across the whole relationship, strong affidavits from people who watched it develop, and prioritize what you get right now. Open the joint account. Get both names on the lease. If one spouse came from abroad, document the pre-immigration period thoroughly. And then document the integration into life here, the new address, the new job, the new school. And if you come from different cultural or linguistic backgrounds, address it directly. Certified translations, affidavits explaining cultural context, evidence that both families have met and accepted the marriage, language learning efforts. Difference is not a weakness in your case. Unexplained difference is. Let me close with the mistake we see most often: submitting only a marriage certificate, relying entirely on photographs, submitting evidence that only covers the last few months, inconsistent dates or addresses across your documents, failing to explain those gaps, affidavits that all sound identical, that suggest coaching, photos with no labels, leaving out everything before the wedding, foreign language documents with no certified translations, and dumping in a huge volume of repetitive, low-quality paper, which does not help you and can actually hurt you. A strong case is never built on one document. It is built on depth, breadth, consistency, a timeline that spans your whole relationship, and corroboration from people other than the two of you. Everything I covered today, every checklist, every category, the full affidavit requirements is in the free written guide our office has prepared. The download link is in the description. You just need to visit our website. If you are unsure what applies to your case, or you are missing documents and do not know what to do about it, call our office before you submit anything at all. That is 508-500-1551. We are the Botelho Law Group at 901 Eastern Ave in Fall River, Massachusetts. Subscribe if this was useful. We publish plain English immigration guidance every week. And every couple watching this, your marriage is real. Your job is simply to prove it well. We can help you do that. This video is for informational purposes, not legal advice. And it does not create an attorney-client relationship. Every case is different. Speak to a qualified immigration attorney about your situation.